I'll put it.
There we go.
Okay, got it. So let me do host. You got to enable my screen sharing.
Oh, I'm sorry. Yes. There you go. Okay. And if everyone can mute just to reduce. Okay, that's good.
So how do we? View, there we go.
Three-quarters of the way down, full screen mode. There you go.
There we go. Okay. So
Perfect.
this is a talk about corporations, and there's so many fallacies about corporations that I decided to do a talk to sort of list them. So let's start off with the Citizens United decision by the Supreme Court a number of years ago, and this question of personhood. And the usual narrative you get in America on the left is that the Supreme Court said that a corporation is a person, a legal person, and therefore it has the rights of First Amendment free speech and all that. And just like an individual or just like a trade union or some other, say, nonprofit association is able to contribute, then corporations should be able to too. And that's not the reasoning behind the Citizens United decision. So if you read the dissent from Justice Stevens, it's quite good dissent. And the reason for the decision was that just as trade unions are associations that have members, so corporations are associations that have members. In this case, they're thinking of shareholders. And so if trade unions are allowed to have associational speech, then corporations should too. And so that was the key concept here, is associational speech. And so people on the left have suggested, when they think that corporate personhood was the reason, because it's a legal person but not a natural person, that say we should limit free speech to natural persons, which would probably be the worst outcome of all, because then individuals like Charles Koch or John Q. Public could have all the public voice they can afford. And so the way you amplify individuals' public speech is through associations. And so the idea of only allowing natural persons to have freedom of speech is not a good decision. And also the whole idea of abolishing corporate personhood is also a bad idea. And first of all, the word person here is quite not necessary. The whole point about a corporation is it's a separate legal party. And they always say separate legal person, but you can just as well say separate legal party, which means the assets and the liabilities of that legal party are not the personal assets nor the personal liabilities of the owners or the members. And that's true in any corporate association and so forth. So if you were to abolish corporate personhood, then that means all non-trivial investment in economic enterprise could only be undertaken by rich people, and because you wouldn't have limited liability, and only rich people could afford the risk of a huge investment. So and also the corporations are described as having limited, the shareholders are described as having limited liability, but that's another misnomer, because the shareholders have no liability for corporate debts or corporate liabilities. And so what people mean when they say they have limited liability is that you can just only lose the amount that you invested. But that's true even for non-equity investments. If I loan somebody money or loan money to a company and the company goes bankrupt and I get screwed, then they're not going to be able to come after me. I'm not going to lose any more. So the whole language of limited liability is misleading people, that individuals have no liability for liabilities of the corporation, and they have no ownership of the corporate assets. In other words, they can't go in a corporation and say, well, this desk is mine or this computer is mine. So that the assets are fully owned by the corporation, and individual shareholders have zero ownership of the actual assets of the corporation. Fallacy number 2 is when you have the situation which we've had throughout the 20th century, where ownership and control of corporations, of large corporations, is very much divorced. We have ownership is spread all over the stock market, and the governing power is in the hands of management. It can pretty much ignore the shareholders, because it takes so much money to organize shareholders scattered all over hell and back to vote on one, alternative slate for the board of directors to throw out the management. So management pretty much has their own control. Then people say, well, the solution is shareholder democracy. So let's have shareholders fix it up so shareholders can really vote in a more realistic way or something. And this is a fallacy, not only because it's impractical, which it certainly is, but also the word democracy is a system of governing people. And the people of the absentee shareholders are not governed by the management of the corporation. So democracy is not a system for governing property. We don't say the farmer governed his fields democratically or he governed his herd of cows democratically, because it's a system of governing people. And as Abraham Shays at the Harvard Law School says, this analogy that's been very congenial in legal history, shareholders are the electorate, the directors, the legislature, and the policies are committed, the officers of the company, the managers, for execution. But shareholder democracy is misconceived because shareholders are not the governed, whose consent must be sought. And so managers cannot give orders, does not govern the shareholders. It's the shareholders' property that they are entrusted with, but democracy is not a concept for managing property. And so you could also look at it this way, that if you went through all the trouble of holding elections and organizing, it would be like the people of Russia having democratic elections, but of the government of Poland, because the government they're electing isn't governing the electors, it's governing the people that work in the company.
Or of Ukraine instead of
Ukraine.
Poland.
So fallacy number 3, very often you get this narrative that a lot of people are affected by the corporation, what the corporation does. And there's this old principle, it goes back to medieval times, of all that are affected should have a say, in some Latin phrase. And this ignores this crucial difference between negative and positive control. So the negative control is the right to say, no, you're not going to do that to my person or my property. So you're constraining another party's decision to protect your legitimate interest. And that is negative control right. And that's confused when you just say have a say with the positive control right to actually play a role in the other party's decision. In other words, this whole idea of stakeholder governance in corporations, says that consumers should be represented on the board of a corporation and so forth, whereas in fact the consumers need to have more effective negative control rights, and that includes the most basic one is the right to go elsewhere. So you have don't have a monopoly where you don't have a choice to go elsewhere to buy something, and so competition in the marketplace, antitrust, enforcing antitrust laws, and so it gives consumers negative control rights. They can go elsewhere, And aside from being impractical to have, everybody who has an iPhone somehow make a decision as to how Apple changes the iPhone and its future models and so forth is ridiculous. So most of the stakeholder suggestions about redoing corporate governance to include everybody else who might be affected is simply admitting that the negative control rights are often ineffective, and they're not going to be answered by having some say in a corporate decision, because there can only be one majority in a corporate board decision, and all these parties cannot have a majority. Each one may be like a majority. So what they really need is to make their negative control rights more effective. And that's what regulation is about in the economy. That's what antitrust is about in the economy, and so forth. So that's the effective interest principle is not a sort of valid argument, because in favor of stakeholder governance, that you have the right, just because you might be affected, to actually make another party's decision. Fallacy 4, the people that say shareholders don't own the corporation. And so there's a number of legal scholars now that are trying to approach the corporate governance debate, which is an old debate. It's been going on throughout the whole 20th century, as I said. And they make the observation that shareholders don't own the corporate assets as their personal assets, as if that was some kind of revelation that they've just discovered, that you can't go in and say, this desk is mine, or this computer is mine, and so forth. But that's simply the basic idea, that the corporation is a separate legal party than the members, and members is, in this case, mean shareholders. So the debts of the corporation are not the personal debts of the shareholders, and the assets of the corporation, the other side of the balance sheet, are not the personal assets of the shareholders. So that's been the case since the Middle Ages, and recent scholars in corporate governance that discover that the shareholders don't own the corporate assets individually is hardly a new thing. So when they say, that therefore shareholders don't own the corporation, at best they're just saying this is a linguistic concession, because the shareholders, if they have a majority vote, they can sell the whole corporation to somebody else. They can change the board, change the management, and sell the whole corporation. So if that's not ownership, then I'm not sure what is in that sense. So they don't own the specific assets of the corporation, but they do. The shareholders in the conventional corporation are the ones that have the ownership rights over the whole thing, and because they can sell it, they can throw out the board, throw out the management, and so forth. So that's fallacy number 4. Fallacy number 5. Now we're getting a little more technical and specific. And the point is here to start off by distinguishing personal rights from property rights. And personal rights are something that's attached to the person because they qualify for it or have a certain functional role. So for example, why do you have the voting rights in the municipality where you live, or in the state where you live, and so forth? And those are rights you have to qualify for. You don't have to buy your voting right. You can't sell your voting right. You qualify for it. And the main way to distinguish personal rights from property rights is, are they bequeathable? Can they be inherited by somebody? And personal rights cannot be inherited. When you die, your voting right in elections does not pass to your to your heirs. Whereas property rights are distinguished by, they can be, in general, unless otherwise restricted, freely bought and sold, and there's no qualification other than being able to afford it to buy a property right. And so the difference between personal and property rights is easily seen by looking at the bequeathability or inheritability right. So if you look at cooperatives now, cooperatives are corporations, but what they differ from the conventional corporation is that the membership rights are given to people that have a certain qualifying role. So they're not property rights in that sense. And so in a consumer cooperative, the qualifying role is to shop there. And that's called patronage. And so in all the different types of cooperatives, there's a certain notion of patronage, and patronage is that functional or qualifying role that someone needs to have to be a member. And we may use the word owner, but the word owner is then inappropriate because it's not a property right. You can't sell it to somebody else and so forth. So if you're in an agricultural marketing co-op, then you sell your produce through the marketing co-op that qualifies you for membership. And in a worker co-op, it's working in the worker co-op. Now, one of the legal scholars who has actually tried to understand cooperatives and to write about these issues, Henry Hansman. I think he's now emeritus, but a Yale University law professor. And he says that a conventional corporation is a capital-based cooperative where the patronage is supplying capital to the corporation. So he thinks of the shareholders as supplying capital to the corporation. And so it's just a different type of patronage than the other types of cooperatives. But that turns out to be a pretty bad argument because corporate shares are quite distinct from supplying capital to the corporation. And you know, you can buy shares on secondary markets, so you're not supplying capital to the corporation. You're supplying capital to a previous shareholder. You can get shares as a bonus, and you can also just get shares as a gift, or you can inherit shares. Shares do have inheritability. And so in none of those cases do you supply capital to the corporation, but you're a member just like every other shareholder. So the idea that membership is restricted to people that supply capital to the corporation is at best a sort of crude analogy. And when I pointed this out to Hansman years ago, he said, "Oh, it's just an analogy," which is true, not a very serious analysis. So the real question here is, what is the conventional corporation in comparison to these different types of cooperatives where you have personal rights attached to a functional role? So Hansman is right in that in all these cases, ordinary corporations and cooperatives, you do have membership rights, and shareholders are called the members of a standard corporation. And so he says, in that sense, all firms are cooperatives, and you just have different criteria for being a member of the firm. And the criteria he suggested was the supplying capital. We've seen that isn't true. So what is the way in which you can separate out a conventional corporation from a cooperative? And the idea is that you start with the notion of a cooperative. As he says, all firms are cooperative. And then you just take the limit as the patronage goes to zero. So that the qualifying role goes to zero, and then the membership rights are no longer attached to this qualifying role of patronizing the company. They're just free-floating rights that anybody who can afford to buy them. And that's what the conventional corporation is. It's the limiting case of a cooperative where patronage goes to zero. And so since it goes to zero, you don't have to qualify anymore. You can buy these rights, you can be gifted these rights, you can inherit these rights. And that's how the shares in a conventional corporation become property rights, as opposed to the membership rights in cooperatives, which are personal rights, as we saw. So a conventional corporation is essentially a zero patronage cooperative. And that's what gives us its universality, because corporations can be owned by anybody and everybody, and because there's no qualifying role. It's just a piece of property that if you can afford it, or you have a rich uncle that can bequeath it to you, or whatever way you can get it, and you can be a member just like everybody else. So that's the correct answer to Hansman's argument. Yes, all firms are cooperative, but what's different about a conventional firm is that you've taken the limit as patronage goes to zero. So it's the membership rights become these free-floating property rights. Fallacy number 6, and this is a very interesting fallacy, is how the notion of membership gets corrupted. So here we have to go back to the history of the whole idea of a corporation. And this goes back at least to the Middle Ages, or goes back to Roman times, but also developed quite a bit in the Middle Ages. The idea of a universitatis, I think, was one of the medieval words for it. So the whole idea was, it's when you have a bunch of people joined together to do some joint activity or some joint undertaking, then that should qualify as a separate legal party than those people as individuals. They've joined together, they're doing something in common. And so that's the original idea of a corporation. And that has been transformed in more modern times into the idea of a cooperative. So in a cooperative, you have allegedly people joining together to do some joint activity. So we want to look at how this original notion in the Middle Ages has been corrupted in 2 different ways. So one way it's been corrupted is to say, yes, it's the legal embodiment of people joined together to do some cooperative activity. Then you say, okay, well, take a consumer co-op. What's the joint activity undertaken by the members? And so the members are consumers, and what activity do they carry on together? Consumption is not a joint activity. Consumption is done individually or in the family. And so in a consumer co-op, and we're talking about a consumer co-op as a business, not just a buying club. It's not usually called a cooperative at all. And so they don't do consumption as their joint activity. And the actual work of the cooperative, which is a joint activity of human beings as a distribution business, that's done by the employees. So you have this notion of a consumer cooperative as if consumers are joined together to do something together, but they don't do anything together. They consume individually, and the people that do join together to the actual distribution business are not the body of consumers, but the body of employees. And people are sort of guilty about this. And so a lot of co-ops, not a lot, but some, have this vestigial work requirement. And this is sort of usually pretty pathetic. So you have a thing where a consumer member will come in, say, once every couple of months and pass out free samples of some cheese in the aisle, and because they don't know how to do anything in the business and just mess it up, and so they hand out some sample of food or something like that, which you often see in ordinary supermarkets. And it got even humorous when in one of the upscale cooperatives in Brooklyn, the work requirements were done by the nannies or by the servants. So the people got very upset that you know, they're not actually doing the work. They're sending their nanny to do the work, and they don't seem to realize that that's the whole idea of a consumer co-op, is consumers aren't doing the work. It's done by the employees anyway, and so they don't have the self-perception that the sending somebody else to do the real work in the cooperative activity is what they do, and it only becomes obvious when it's this vestigial work requirement is done by their nanny. And if you look at other non-worker co-ops, you get the same thing. The actual activity of the cooperative as a business is done by employees, not by the members. And so say you have family farms that want to sell their milk or their crop, cranberries or something, through a producer marketing cooperative. They're not producing the cranberries cooperatively. They're producing them in family farms, on individual farms. And so what the cooperatives are doing, what activity that is is taking the milk or taking the cranberries and then producing all sorts of processed products, making butter or yogurt or whatever it is, or making ocean spray cranberry juice. And that's all done by rented workers, by employees. So, so these non-worker cooperatives were also have degenerated in the original sense that the people that the joint activity that they supposedly came together to do isn't done by them. It isn't done by the consumers in a consumer co-op. Isn't done by the so-called producers in a producer co-op, where their production of the cranberries or the milk is in family farms, but the actual activity of the cooperative is this value added to the produce, to the milk or the cranberries or the sun-kissed oranges or whatever it is. And that's all done by employees, not by the members of the co-op. And the members of the co-op are now usually agribusiness corporations anyway. So all these other types of cooperatives where the actual joint activity is carried on by employees represent a real degeneration of the notion of cooperative, and yet that's not recognized, not to mention discussed, by the International Cooperative Alliance. It still has this rhetoric of, well, people come together and cooperate to do something, and then use the word cooperation as if it's a very value-loaded good word. And anybody who studied economics knows that, or anybody who's read Adam Smith even, that whenever businessmen get together, they love to cooperate. That's how they can screw the consumers more, is to build up various cartels or trust or conglomerates or whatever it is, and to gain market power. And so the idea that somehow cooperation is always good is just something I don't understand. But my point here is going back to this medieval notion of the corporation. The problem with corporation is not the original idea. People engaged in a joint activity having a separate corporate embodiment, and that's a great idea. And that's the only way that people who are not already rich can join together and start a business or something and not be personally liable for the debts of the business. So before this notion became corrupted, the medieval times, this was the concept behind the guilds, the borough, municipal corporations, religious orders, monasteries, and universities. And these were all where people came together and carried out themselves some joint activity. And so what has happened over the centuries is that the people come together, as it were, or they form this corporation, but they don't do any joint activity. And the joint activity is done by people that are rented from the outside, because the organizations we're talking about are not where people are doing something together, but where they want to make money and do something that is economically productive. And so they hire people to do that, and then they are the owners in that conventional type of corporation. So this is sort of a description of how the notion of corporation has evolved from the medieval times. And one way it's degenerated is in the notion of a cooperative, where the members of the cooperative aren't doing anything cooperatively, but are hiring people to run the consumer cooperative, or to process the milk or the oranges or the cranberries into some other product. And the sort of enabling institution in all these cases of how the medieval notion of a corporation degenerated is the hired labor relationship, the employment contract, the renting of people, because they brought them in and they're the ones that actually do the work. So that's the problem. The problem is not corporations. The problem is not the original idea of the corporation. The problem is this idea that the people that actually carry out the joint activity of the corporation are not the members, and the members don't carry out any joint activity. So here is a quote from the same fellow I quoted before, Abram Shays, a law professor, Harvard Law School. And so he describes here the way in which the medieval notion of the corporation was corrupted. So we can perhaps note a final irony, at least. The concept of the corporation began for us with groups of men related to each other, by the place they lived, like in the boroughs, or the things they did, the monastery, the town, the guild, the university, were only peripherally concerned with what the members owned in common as members. So it wasn't about assets, it was about their joint activity. But then over the centuries, it changed to something else. So Shays goes on and he says, the subsequent history of a corporate concept can be seen as a process by which it progressively became more formal and abstract. In particular, the associative element, in other words, people coming together to do something, was refined out of it. And I made the point, yeah, it can be refined out of it because you can hire people to do that part. In law, it became a rubric for expressing a complicated network of relations of people to things rather than among persons. So in other words, the corporation evolved from, rather than being an association, persons carrying out some activity, it became a big piece of property, could be owned by anybody, and then the people doing the actual joint activity are rented from the outside, the employees of the corporation. So he concludes the aggregate material resources, that's the assets of the corporation, rather than the grouping of persons, became the feature of the corporation. So that's the medieval notion, was a corporation was a grouping of persons doing something together. But today, corporation is just an aggregated bunch of material resources that are owned as a separate legal party from the shareholders, and they can be bought and sold routinely. And the historical change was due to the actual work of the corporation being done by these outsiders, people that are rented, employed, hired, leased, whatever word you want. So the members become just the owners of the aggregated material resources of the corporation as an asset, and the employees who use those resources to produce the products or services of the corporation are simply these outsiders. Moreover, I'm just now commenting on people's sort of ideology. It's interesting how people have been trained to instinctively think of democratic governance, actually people who are governed being the ones who elect their governors, for an aggregation of real estate like in a town or a city or a state. So you think of that sort of obviously a town, township or city, a municipal corporation or a state should be governed democratically. That's sort of obviously, and when you think of a town, making a town into a corporation that you can buy and sell shares in it just strikes us as completely weird. And but we had a completely weird occupant at the White House recently, and one of his ideas was to buy Greenland. And he said, well, it's just a real estate deal. And the pundits were in a big uproar. I mean, how could you think of buying Greenland? What about the people, the population? But when the corporations are routinely bought and sold as just a aggregate of material resources, pundits do not bat an eye. It's just a capital asset deal. So you're just selling assets. So it's interesting that in one context, people think, well, it has to be democratic. It's a real estate area, a town, city limits or state limits, and has to be governed democratically. But whereas this occupant of the White House, it's just a real estate deal, and people can stay or leave. They're free to go. And so corporations are sold routinely. Yeah, employees are free to stay or go, and it's just an asset deal. And yet, then nobody bats an eye. That's the normal stuff. That's what's normal. So the change that's needed is reconstituting business corporations as democratic firms. So the members, the owners, and owners in scare quotes here, because in this case, they would be personal rights and not, their membership would be personal rights and not a property right, are the people carrying out the business of the corporation. And so I've gone through a long sort of argument analyzing various fallacies about corporations to arrive at that conclusion. But it's interesting, I got a quote here from a British Tory conservative parliament member, and he was in the education cabinet of some governments, Lord Eustace Percy, and also a lord, a hereditary lord. And in 1944, he said this: "Here is the most urgent challenge to political invention ever offered to the jurist and the statesman. The human association, which in fact produces and distributes wealth, the association of workmen, managers, technicians, and directors, is not an association even recognized by law." So this is the point I made. The actual people doing the real joint activity of the corporation, they're not even, don't even form a legal body. And the corporation, the legal body, the association which the law does recognize, the association of shareholders, creditors, directors, is incapable of production. It's not even expected by the law to perform these functions. We must give law to the real association, namely the people that work in the firm or who do the actual joint activity of the firm, producing and distributing wealth. Give law to the real association and withdraw meaningless privilege from the imaginary one. So that's a statement by a British Tory lord in 1944 after World War II. And basically that's exactly right. This is sort of a brilliant moral insight by this fellow in this lecture. And that's the general conclusion that we came to, that the problem is not the idea of the corporation. The problem is the separation of the idea of the corporation as people carrying out a joint activity by having the joint activity carried out by these people who are all employees, and then yet recognizing the members of the corporation as the shareholders and creditors, none of which can actually do the work of the corporation, can actually produce and distribute the wealth. So it's a brilliant insight, of course, hardly on the agenda of the British government or any other government.
David, is that an implicit justification of unions, do you think?
Well, unions are just collectively selling. It's like a cooperative to collectively sell your milk, except you're collectively selling your labor. And so we're suggesting here abolishing the whole employment contract, not making it a seller's union, but so they are the members of the company, not outsiders who are bargaining for a better price for what they're selling. So it's not a union idea, but of course, unions have been related to this. And if you go back to the 19th century, the unions in those days were what were called reform unions in the United States. And their goal was to create what they called the cooperative commonwealth and to abolish the wage system. In other words, to abolish the employment relationship, not to bargain about it, get rid of it, and to have cooperative commonwealth. So firms would become worker cooperatives. And in the early 20th century, you had this contrast between what were properly called trade unions versus these reform unions. And the trade unions said, we will not challenge the owners. We will only bargain for more, in the famous phrase, in the employment contract. So you can guess which unions the employers, the owners wanted to deal with, and eventually they learned how to even eliminate them. So you have in the United States now, among all the democratic industrial countries, we have the lowest degree of unionization, something like 6% in the private sector. So it's what about the labor movement used to be? I don't call it the union movement, I call it the labor movement used to be, but it's not what the 20th century labor movement turned into, just a union movement, and to try to get more by selling their labor. So Brian, can you stop recording now so we